Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. Our topic of conversation for this show is medical malpractice. So if you know somebody that this is particularly just right down their alley and something they need to learn about, maybe pick up the phone, give them a call and tell them don't forget this show, because that's our topic of conversation for the next half hour. Now, I'm about to introduce our panel of experts, but before we do so, attorneys from Hollis, Wright, as you may know, they're standing by during each and every show. For the next half hour, you can get some free legal advice from an attorney. That conversation is for real, it's confidential, and it's all fair. To take advantage of that opportunity, you can text 205-670-1949. You can call 205-324-3600 or 844-529-8255. That is 844-LAW-TALK. Would love to have you join the conversation and take advantage of that opportunity to speak with an actual attorney standing by live. Now, leading our conversation, as he often does, Josh Wright, managing partner of Hollis Wright. Good to see you, sir.
Good to see you, too. Hope you had a great week.
I did indeed. Thank
you.
You
know, we've done a show on medical negligence and medical malpractice and kind of how the medical statute applies in cases. And we've done a lot of different spins on this over the years, and we're going to be talking today a lot about kind of what you do if you find yourself in the circumstance where you feel like you didn't get a great result. There are a lot of incredible doctors in Alabama, and we talk about this a lot whenever we do these shows. And then there are some doctors that aren't doing it the right way. We're talking about the doctors not doing it the right way today, and there are circumstances where people have a bad result, but there is no medical negligence, and Josh Vick, who is our special guest today and our expert in this area, is going to talk about that. But we're also going to be talking about circumstances where someone's provides substandard care and what your rights and options are. So, you know, when we handle cases like this, we go to the experts. And Josh's firm, Goldesich, Vick & Folk, is an expert in this area. They handle a lot of these cases. And a lot of times we'll ask them to take a look at things if we see it, because it's not something we spend a lot of time on at our practice. But first of all, Josh, welcome to the show.
Thanks for having me.
Thank you for coming on. This is, this is a super unique area of the law that requires a lot of expertise to be able to handle these cases. They're very expensive, and you know, I know this is just an area that is in the sweet spot of your law firm. How did you get involved in this? And it may be as easy as, you know, when you joined the firm, it was a specialty and you kind of got yourself into it, but how did you get into this area of the law?
Right, yeah, I've been with the firm for about 8 years now, and we handle a wide variety of claims, but my practice has been specialized in representing patients or families of patients that have been injured through medical negligence. And it really just became sort of a passion of mine. I handled a few claims for some clients and saw the tremendous impact that it had on them when, you know, anyone can have a mistake, a bad day at the office, but when it happens in the healthcare industry, the results can be just catastrophic. And so handling a few claims early in my career sort of lit a fire for me. And so that's how I've come to focus a good part of my practice on patients.
So explain just in general terms, how does in general, how does a medical negligence case work? It's not as simple as just saying, well, you're going to go file suit against your doctor. I mean, you've got to file in certain jurisdictions, you've got to file certain statutes. I mean, it's a little more complicated, isn't it?
Correct. It's an extremely complex area of law. Like I said, I've been doing this for 8 years, and I learn something new every day with it. It's, you know, you have to file in the specific venue where the medical negligence occurred. So if you're injured at a hospital in Birmingham or in Mobile, you have to file in that specific venue. And it's one of the more difficult areas of law in Alabama to be successful in, because you have to prove everything through expert testimony. So you have to have experts from across the country who are willing to come in and review a patient's medical records, review what happened to them in their treatment, and then provide testimony about whether the doctor violated the standard of care and whether that caused the patient's injuries.
Talk a little bit about the standard of care, because the standard of care is required. You've got to prove that a physician violated that standard of care in order to even have a viable cause of action. Is that fair?
That's correct. That's correct. And that's why we have to do a lot of work on the front end of a client's case to to investigate and obtain medical records and review them and have expert consultations. Because the standard of care, it's a medical term and a legal term. It's basically the level of care that a physician or a nurse or another healthcare provider is expected to provide to their patients in that particular area, in that particular circumstance. And so it's a national standard. So if a doctor is practicing in Alabama, he's expected to use the same level of care and experience and diligence that a doctor in California or New York or anywhere across the country is supposed to use. So, for instance, if a patient comes in complaining of chest pains and pains down my arm and up my neck, and I'm really fatigued and I'm over 50, and you hit these check marks, and the doctor is supposed to realize, hey, those are classic symptoms of a heart attack. And when he realizes that, he's supposed to take certain actions, get certain tests done, and that's what the standard of care requires.
And the standard of care, David, weeds out, because of how heightened the standard of care is to prove that someone's violated it, it weeds out the types of claims that are simple mistakes and simple issues that can take place in the everyday world of healthcare in Alabama, and it requires you really, in many circumstances, to meet a heightened standard in order to be able to be successful in a claim for medical negligence, and that's just the way the legislature has created the statute.
Got a question here. I spoke to an attorney about a case, and he told me that he didn't think we could prove the elements of a malpractice claim. What does that mean?
Well, that's obviously don't know the specifics of that case, but what the attorney is probably referring to is that there are several elements that you have to prove in order to be successful in a medical negligence claim. You first have to prove what we just discussed, that the doctor or the nurse violated the standard of care. They didn't provide that level of care or treatment that other doctors would have given in the same circumstances. The next thing you have to prove is that the violation of the standard of care was the direct cause of your injuries. And so both of those under Alabama law have to be proven through expert testimony. And that's why cases in Alabama of medical negligence are so difficult and so expensive, is that you have to prove everything through expert testimony and hiring these experts to come in and review the claims and testify on behalf of a patient. And so that's, like I said, I don't know the facts of that case, but because the standards are so rigorous, as Josh was saying earlier, that's probably what their lawyer was saying, was that he didn't think they could meet those rigorous standards for proving the claims.
Yeah, do you see it's easy to get experts in these cases from Alabama testifying related to the standard of care in Alabama, or do you have to go outside of Alabama to find experts? What do you see generally?
That's a great question, and we get asked that a lot, particularly by juries after cases. Yeah. You know, we have experts from California or New York or Massachusetts, and it's basically to do with doctors in Alabama not wanting to testify against other doctors in Alabama. And at the same time, when we have these cases, we try to go out and get the best of the best in every particular field. And so we end up going to other states or other parts of the country to find the expert who's the most qualified to talk about these areas.
I know we're getting ready to go to break. When we come back, I want to talk a little bit about trends and things that Josh is seeing and the types of cases that he sees most often, and kind of the things that he evaluates, because I think that'll help folks that are sitting on the couch right now watching this, wondering whether or not they've got a malpractice case.
That sounds good. We're stepping aside right here, our first break of the evening. As we do so, a reminder, check out Hollis Wright on social media, Facebook, Twitter, Instagram. Just search the term Hollis Wright. Find them there, a great educational, informational resource. Stay tuned. We are coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into the attorneys. Appreciate you being with us tonight. Hey, before we get back into our conversation, want to remind you, make sure that you understand how you can get in touch with us. You can email, you can call. The numbers you need to know, the phone numbers you need to know. If you want to text, it's 205-670-1949 or 205-324-3600, 844-529-8255 or 844-LAW-TALK. Josh?
That's a mouthful.
It is. It's a lot of numbers.
That's a lot of numbers. 844 Law Talk is what I remember. Right?
Yeah, that'll stick
if
with
people need to call. All right, so talk with us, Josh, just a little bit about what do you see most often that you're evaluating? I mean, is it misdiagnoses? Is it circumstances where someone had a bad result from a surgery? Is it all the above? I mean, what do you see the most?
I would say, we see a lot of bad results from surgeries, but the far and above the biggest issue we see are misdiagnoses. It's a physician has, when he's treating a patient, what's called a constellation of symptoms. And they're looking at that and they're trying to come up with their differential diagnosis, which is the list of all the possible conditions that could be causing those symptoms. And they're required by the standard of care to rule out the most dangerous. So if you have 5 potential causes for the symptoms that you're exhibiting, and one of them could kill you within an hour, the physician has to check and do the testing to make sure that that's not what you have before they move on to a simpler diagnosis. And so we see that a lot. Patients coming in with symptoms of a heart attack and they're sent home with a diagnosis of a pulled muscle, or patients coming in with meningitis and they're sent home with a diagnosis of a sinus infection. And so these are really serious conditions, and if they're not picked up and they're not caught with the proper diligence on the part of the physician, then it can lead to catastrophic results for the patient.
Now, not every bad result equals a medical malpractice case. Is that fair?
Of course not.
And that's what you're oftentimes evaluating, to make sure that the cases that you guys are taking are clear standard of care violations.
Absolutely, absolutely. And that is, like you said earlier, we have the utmost respect for the medical physicians and the nurses and the people who are out on the front lines doing this type of work. But at the same time, these cases are extremely difficult to win, and they're extremely expensive. And so attorneys don't just fire off, any claim in a medical negligence situation. They are extremely well vetted before the complaint ever gets filed. The records have been reviewed. We've had expert consultations, and so you can bet that if a claim gets filed in the medical negligence area, it's got merit, and it's a claim that deserves to be heard by a jury.
Now, medical malpractice claims are broader than just against physicians. Nursing homes are involved in the Medical Liability Act. Nurses sometimes are involved, physical therapists, other areas can be involved in a medical negligence case. Is that fair?
That's absolutely right. You have individual healthcare providers who can commit medical negligence, such as doctors, nurses, like you said, physical therapists. But you also have corporate entities, hospitals, physician groups can be held liable for medical negligence. And one of the interesting questions that we get from clients all the time is, I didn't really technically receive medical treatment. Can there still be medical negligence there? Yeah, if you show up to a hospital and are sent away without receiving treatment, that's medical negligence if you needed treatment or your symptoms warranted further investigation by your doctor.
All right, now I want to set the record straight on something. I see the pundits on these politically national stations where you hear people say that healthcare is being driven up by medical negligence cases across the country. Set the record straight on that. Is that really accurate?
We hear that a lot, and the fact of the matter is that's coming from lobbyists, people in Washington who represent insurance companies and the insurance industry. And what they're attempting to do is limit a patient's right to recover when they've been injured, and not only limit their ability to file claims, but limit the amount of compensation they can receive for their industries or for their injuries. And so every year we hear claims of some new explosion in medical malpractice litigation, when the statistics, if you go back and look, show that medical malpractice claims have declined over 25% over a 10-year period, and they only make up a little bit less than 1% of all claims in state civil court. And so there's really no explosion in any type of litigation, and the studies that we've gone through pretty tirelessly and reviewed have showed that out of every 5 people who suffer some significant medical negligence injury, only about 1 is going to bring a claim. It's a little bit less than 20% of people who have legitimate medical malpractice claims that actually institute a legal action. And so the big push by these lobbyists in Washington and even down in Montgomery in the state capitol to try to talk about a medical malpractice crisis or some explosion in medical malpractice claims that is driving up healthcare costs it's really more about protecting insurance industry and not about protecting patients and patients' rights.
Yeah. It's that's a debate that's been going on, David, for decades. As long as I've been practicing, it's been around, and it was around a long time, long before I ever started practicing.
Yeah. Question we've got here. I've been the victim of medical malpractice, or at least they believe they have. So how quickly do I have to file a claim is what they ask. So statute of limitations, is the clock ticking for them?
That's exactly right. Statute of limitations is the amount of time that they have to file a claim, and there are a lot of factors at play, but generally speaking in Alabama you have 2 years from the date of the medical negligence, or if the negligence caused a death, you have 2 years from the date of that death. Now there is one really important exception, and that is if your child has been the victim of medical negligence before they were 4 years old, then you have until their 8th birthday to file a medical negligence claim. But generally speaking, if you think that you've had a medical negligence incident, you have 2 years to bring a complaint. And one, I'm sure Josh, you're aware of this, one important part of that is people sometimes mistakenly believe that if they file a complaint with the Alabama Board of Medical Examiners or they file a complaint with the hospital, that that's meeting their requirements for the statute of limitations, and that's not accurate. In order to comply with the statute of limitations, you have to have an attorney review your claims and file an actual civil action in state court. That's what the statute of limitations is referring to.
We get this question a lot, Josh, and explain this to me. If I'm aware that my physician who engaged in medical negligence was involved in a medical negligent circumstance with another patient, over the last several years, can we present that to a jury? Talk about that for a minute, because there's the statute that prevents that.
Yes, there is. That's one of the reasons that we tell our clients, Alabama is one of the toughest places in the country for proving a medical negligence claim, because as you know, when we get in front of a jury in any type of civil case, we can't tell the jury, oh, this person has insurance to cover their claims, or they have this money set aside to cover a claim for injuries. Alabama's statutes take it a little bit farther than that, and they say in a medical case, you can't tell the jury about any other times when the doctor committed malpractice, and you can't even tell the jury if the doctor was punished by his hospital for this particular incident that we're here to talk about in that specific case. And so it makes it extremely difficult when you have a doctor or a nurse or any other healthcare provider that has committed malpractice on other occasions, but you're not allowed to present that information to a jury.
All right, so I know we're going to break, but that can't be underscored enough. If you think about, for example, a trucking case that maybe my law firm would handle, we're able to go into the history of that trucker, all the other accidents he had, all the other disciplines he had. That is totally different in a medical negligence case, just not allowed to do that. And so that's another thing that weighs into the evaluation of whether or not a medical negligence case is even filed in the first place. It's just another factor that has to be considered. And the statute is really in favor of physicians in Alabama, so those cases have to be properly vetted, properly assessed to ensure and maintain that the claim is valid and viable when it's filed. When we come back, I want to talk about this concept of informed consent, what information you must be given in order to make an informed consent. We're going to talk about that, and I'll ask Josh about it.
All right, our final break of the evening. You want to take advantage of that opportunity to speak with those attorneys standing by live. A few minutes to do so. Take advantage of that, and it's a great opportunity for you. Stay tuned. We've got more of the attorneys coming right up.
I'm attorney Bobby Bell with Hollis Wright Law Firm. In today's world, social media is all around us. It is common for many people to post on social media regarding their life and activities on a daily basis. Facebook, Instagram, Twitter, and similar social media are a great way to stay connected to others and share your experiences and thoughts. Some seemingly innocent social media posts, however, can have devastating effects if you're involved in litigation, especially in a personal injury claim, a contested divorce, or a child custody battle. Courts regularly allow adverse parties access to the other side's social media. accounts, allowing relevant posts to be presented as evidence. These rules have allowed social media to become a hotbed of information in the litigation world. In fact, we are seeing more and more preservation orders issued by courts requiring you to collect and save any and all social media activity. Therefore, it's advisable that even before there's litigation, lawyers should advise their clients that social media content may be discoverable. Here are a few helpful tips. 1. Do not post anything about the case. This includes posts regarding conversations or meetings with your attorneys, remarks about your injuries, negative remarks about the opposing party. Do not post anything you would not want read in open court to either a judge or jury. 2. Avoid new friend requests from people you do not know. Many law firms and insurance offices may attempt to have employees follow you on social media in an attempt to gain information. 3. Limit adding new photos, check-ins, photo tagging, etc. Seemingly innocent posts may be used against you. Regular check-ins at restaurants, parties, or other events with friends can cast doubt on any claims of loss of enjoyment of life, pain and suffering, or emotional distress, since you appear to be living life as usual. 4. Increase your privacy settings. Many social media sites frequently update and change their privacy settings. In the litigation context, it is possible you may have to preserve and present anything you posted. Therefore, we encourage you to be smart and careful when using social media. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WPTM 13.
Welcome back into The Attorneys, our final segment here. If you want to join the conversation, under 6 minutes remaining in the show. So the clock's ticking, so go ahead and take advantage of those opportunities to join this conversation.
And we actually have lawyers standing by
right now
to answer calls, texts, emails, etc. So folks are there if you've got an issue related to this topic or to other related topics.
Absolutely.
All right, so Josh, when we went to break, I was talking about informed consent. We actually get a lot of questions about this, and it doesn't come in the context using the term informed consent. It comes in the context of people will call the show and say, I was not told the following information about what I was about to undergo in this surgical procedure or in this procedure, and we have to sometimes explain or get them to folks like you about informed consent. Can you just address that generally, what informed consent is?
Absolutely. It's a legal term, but basically it means that a doctor or a nurse has to tell you what type of health care or treatment they're going to be providing to you. And they have to tell you the type of procedure they're going to perform or the medication that they're going to be prescribing. And then they have to go into more detail with you and educate you on any side effects that might arise and any risks and also any alternative treatments that you might have available to you. And that's really important because it's important, I know, to everyone to be able to make an educated decision about the medical treatment that they're going to receive.
Yeah, and that's ultimately the issue is you want to place the patient in a position to be able to make a decision about their own health care as best you can. And if you're not placing the patient in that position, you may be responsible for not providing appropriate informed consent. And so it's kind of a big area of the law that we see a lot of questions arise out of.
I'm sure. Question we've got here, what kind of compensation can I receive for a medical malpractice claim?
Well, unfortunately, David, we're not able to go back in the time machine and fix people when they've been injured. So the only thing that our legal system allows is financial compensation for injuries. And so the two main types that you can receive in a medical malpractice situation are compensatory damages, which are meant to compensate the injured party for their loss of income or their loss of enjoyment of life or their pain and suffering and lost future earnings, things like that can be quantified. And then the other aspect is what are called punitive damages. And punitive damages arise in the medical malpractice field normally when a patient dies or when the negligence of the healthcare provider gets to such a level that it becomes a conscious disregard for the safety of the patient. And what happens in that situation is punitive damages are awarded, and those are intended to deter the doctor or other doctors like him from acting like that in the future. It's basically a warning to say you can't let your practice drop to this level and injure patients.
Do you see a lot of medical negligence claims that are in the nursing home context? Do you handle some of that stuff?
We do. We absolutely do. And unfortunately, it's a wide area of practice in the medical malpractice realm, because our parents and grandparents and people that are in these nursing homes or rehab facilities are completely dependent upon their healthcare providers, and they are often extremely vulnerable. And so when their care is not proper and doesn't meet the standard of care, it can often end very badly for those patients.
And I know causation is tough in some of those cases too, where you've got to weed out whether or not someone's injury was just natural decline of their health versus whether or not it involved medical negligence, and weed through those things.
That's correct, and that's why it takes a really thorough review and expert consultations to look at these records and make a determination.
Right at 2 minutes remaining in our show tonight. Time has really flown by, but want to give both of you the opportunity for a final thought. And Josh, if you would, you go first, please.
Yeah, I think the best advice that I can offer in medical malpractice is that these are extremely difficult and complex cases. So it's not something you want to take on by yourself. If you think that you've been the victim of medical malpractice or that you have a claim, it's important that you speak with an attorney and have them evaluate it and obtain your records and guide you in how you need to proceed.
Yeah, and David, we talked about a lot of issues today in the medical negligence arena. And not every bad result is the result of medical negligence. There are lots of circumstances where declining health or other health-related conditions that you bring to the table when you go meet with that doctor the first time are the cause and contributing cause to the bad result that you had. A lot of times, for example, people may not be doing a great job of rehabilitating themselves after they've been through a surgery, for example, and that could be a contributing cause too. So these are super complicated cases. You don't want to go this alone, and I have seen people try and do that before. You want to get to experts like Josh and his firm that handle these cases, that can truly and completely evaluate them and assess whether or not there's a standard of care violation. And if there is a standard of care violation, then they're going to take those cases. So it requires a lot of work on the front end to make sure you're going to the right lawyers quickly and as urgently as you can.
Some great advice.
Great job.
A really interesting
Thanks
show. Appreciate you two being with us. Appreciate you being with us as well each and every week. Thanks so much for joining us right here on The Attorneys as we wrap things up. Information on your screen there, how you can still get in touch with the firm of Hollis Wright. Have a great week. We'll see you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.